Gorsuch, our position is not that regulate can never mean tax or tariff.
Okay.
Our brief at page 15 gives you an example. A president may regulate cars coming in to the city, and then if it adds by charging tolls or something like that, absolutely, in context it does. Here the context you're referring to, story and so on, says nothing about this case. That is the constitutional context about Congress's use of power.
But it's part of how we understand language is used, and it's relevant for that purpose. And then when you've got licenses, which are economically the same thing as, would you agree they're basically economically the same thing as tariffs?
Sometimes they can be.
Okay, so you've got something that's economically identical to a tariff authorized by this statute. So where does that leave you?
So let me,
as a matter of plain
let me
language.
take the question in two parts. One is about the word regulate, and the other is about licensing. With respect to the word regulate, when it's used in the constitutional sense, it's very different than the sense in IEPA that my friend is asserting. When we're asserting IEPA, we're talking about a statute that is granting the president massive powers. And so the relevant context that I think you look at in asking the question, what did Congress mean in 1977? The best context, the most natural context is, what does Congress say every time they grant the president such a power? And then, there's just one other point on this. Constitutions are read totally differently. Story and Madison are talking about the constitutional phrase, and as Chief Justice Marshall said in McCulloch, a constitution we're expounding the prolixity of a legal code is the opposite of the way you read the Constitution.
I do follow that argument. Okay.
And
what about otherwise? Again, I just really want to make sure I understand. You say that there's a good reason why the Solicitor General didn't make that argument. I'll be curious to see what he has to say about that. But you know, what's your best reasoning why the otherwise language doesn't?
Because it's only a mechanism to implement the 9 powers, and that licenses sometimes can be revenue raising and sometimes not.
Yeah.
And so
if licenses can be revenue raising, and you can do this otherwise through revenue raising things, why wouldn't that capture tariffs?
So because I think, again, our point to you is that that there's two kinds of licenses come in 2 flavors. If an executive order is asserting a license fee to recoup the cost of government services or something like that, as I was saying to Justice Alito, that doesn't look different than the other verbs. That's not revenue raising. It doesn't implicate the founder's concern. It doesn't implicate the concerns you wrote about in consumers' research about the fear of the government.
Well, you're not answering my question, though, Mr. Kacha. I'm talking about just the plain text here. And you're moving to a major questions or a non-delegate. That's the move you're making, which I think, fine, we can consider that. I'm just talking about on the text, okay? It says by means of licenses or otherwise. You've conceded that licenses are economically equivalent to tariffs. And the statute says by means of licenses or otherwise.
Right.
Regulate.
It's only a means, and we looked at the history.
Yeah, it's a means.
Yeah.
Why isn't tariffs a permissible means on the statute?
Because, again, it has to be related to the 9 powers. That
well, a license can be. We have to acknowledge that. And you've said a license can raise revenue, and you've said a license is equivalent to a tariff economically. So what about otherwise?
So, Justice Gorsuch, if the license or the otherwise is raising revenue, then it is a difference in kind from the other verbs. And we looked at the history of licenses under TWIA, and we were not able to find any involving licenses or license fees.
Okay. Last question, a little further afield. The parties discussed a little bit the analogy to the Foreign Commerce Clause. Of course, next to it is the Indian Commerce Clause. And delegations there were very broad initially and involved licenses once again. And why shouldn't that inform our understanding of the Foreign Commerce Clause?
I don't know that I have a position on that. It maybe is a little too afield for me to...
Well, if the president has broad authority in one part of the Commerce Clause, why wouldn't he have in the next door neighbor?
Oh, I see. Because here Congress has specifically been given the exclusive power over tariffs. And so if they're to part with it, I think, as this court has said in J.W. Hampton,
so
which is a tariffs case.
You'd say the same principle would apply with tariffs with the Indian Commerce Clause. Is a tariff-specific
I
argument?
think it's at least the intelligible principles is what this court has used for tariffs specifically, and we think that's the way you should look at this. And then under intelligible principles, this is miles away from any delegation we have ever seen.
Thank you.
Justice Kavanaugh?
Just on the Nixon point, because you said, I think, that the current tariffs are unprecedented. I mean, that was a 10% worldwide tax on every import into the United States, I believe. I mean, we don't need, I just think that's a fact. You have arguments about that. You made good arguments about that, but just wanted that point to be clear. On Algonquin, to pick up on Justice Sotomayor's kind assist, your argument here is that the statute has to use the word tariffs, I think, basically. And we went through Nixon and Yoshida, but then Algonquin, the statute for 232, does not use the word tariffs. It uses adjust imports. And President Ford had imposed, again, a pretty significant tariff on oil imports. It was challenged. It got to this court. Attorneys standing where you are stood up and said the license fee now before the court involves the broadest exercise of the tariff power in the history of the American Republic. In fact, we would have to go back to George III's stamp tax to determine as broad an executive power as claimed in this case. The statute is a simple one. It does not mention the tariff on its face. The argument there was the word tariff was not mentioned, used to adjust imports. The court, obviously 9-0, rejects that argument, in part because, as others have pointed out, the court does a lot of questioning. What's the difference between a quota and a tariff? And what's the difference between an embargo and a tariff? And so when the court writes the opinion, it says we find no support in the language of the statute, for respondents' contention that the authorization of the president to adjust imports should be read to encompass only quantitative methods, i.e. quotas, as opposed to monetary methods, i.e. license fees, of effecting such adjustments. So, on your basic point that you need the word tariff, Algonquin says you don't need the word tariff. And that was President Ford's oil imports. It's 9-0. The oral argument goes through this. Your answer.
There's a lot there, Justice Kavanaugh, so please bear with me. First, I'd like to clarify what our position is generally and then deal with Algonquin. Our position is not that you have to use the word tariff or any other magic word. It's true that Congress has used a specialized vocabulary since the founding, since 1790, using words like tariffs or duties. But as I was saying earlier to Justice Gorsuch, you could even use the word regulate, as our page 15 of our brief says, or you can even imagine something that says, quote, the president may regulate importation by requiring importers to pay 10% of the value of goods to the Treasury. So I don't think you have to use any particular word. The question is in context, is it, does...
Algonquin didn't have anything like that, but keep going.
So Algonquin does have, I think, context that's miles apart from what the government is seeking here to do with IEPA. So first of all, it is a common sense statute. I understand there's some rhetoric by, common sense reading the statute, I know there's some rhetoric by the lawyer who stood here before, which is of course forgivable. But it was a statute about one product. 232 is article by article. It's one product. This is a billion products or even more that the government is seeking. The Algonquin was expressly a trade statute. It was the 1962 Trade Act. It's everything this case isn't. Algonquin had a specific reference to the word duties in a separate provision. Algonquin had a legislative history that was clear as day that the president was given this power. And I understand this court today doesn't look to the legislative history, but the way Algonquin got to where it was by saying the legislative history, the chief sponsor of the act.
I think I'll disagree with you on that. It does a plain text and then says, is there anything in the legislative history to defeat the plain text? So I disagree pretty strongly with you on that, but it doesn't defeat your point. Keep going.
Okay, so I'd also say, maybe the most important point, 232, our argument is not just that you have to specifically authorize a tariff with some sort of word, but also that one way of understanding whether Congress is delegating its awesome tariff power, its awesome taxing power, is to ask, are there limits to what Congress has put in? And in Algonquin, in section 232, the court points to and goes painstakingly through all the limits. The first words of the decision are all about how constrained the statute is. It's a reticulated scheme. The cabinet secretaries have to make certain findings. There are specific statutory factors Congress says the president must look at before acting. There are public hearings. There are limited remedies, quote, to the extent necessary. All of that is in the statute. All of that is in the Algonquin opinion. None of it is in IEPA. That's the problem, and that's why, just like James and Moore, the Algonquin case said this is a very limited decision, limited just to the facts.
Thank you.
Justice Barrett?
So this license thing is important to me. And do you agree that pursuant to IEPA, the president could regulate commerce by imposing a license fee?
I'm sorry, could you say that again?
Could the president regulate commerce under IEPA by using a licensing fee?
Not a fee. So I should have said this earlier, but license is different from a licensing fee. IEPA and TWIA authorize licenses, not license fees, and no president has ever charged, to my knowledge, fees under those two statutes for the licenses. So fees impermissible, licenses okay.
Fees permissible if they cover the costs of the scheme?
Might be. I mean, but once they start revenue raising, you implicate the most serious concerns.
But I thought you conceded to Justice Gorsuch there was no difference between a tariff and a licensing fee, functionally.
If the licensing fee is just to I didn't concede that. And
Okay.
so if the licensing fee is just to recoup the cost of government services, I think that may be okay. I don't think you need to get into it. Here, the government is asserting a power which they say in their briefs to you raises $4 trillion.
So you understand the statute to permit licensing in the sense of permission. Like, we will not allow you to trade with us. We will not allow your goods to be imported unless we license it.
Absolutely. And Justice Barrett, I think like just the natural reading, if you're to look at the word licenses and think, wow, Congress smuggled this incredible power to do all of these different things that the government is doing here, 39% taxes on some countries and others, through the word license. That's
Can you license exportation?
I don't think so, for the reason that,
Well, right now, I actually
Well,
looked into
depends.
this. I mean, I think you, maybe not licensing fees.
Exactly.
But could you license exportation, like saying we're not going to allow certain products that have national security implications to be exported?
Yes.
So licensing could be used in that sense,
Correct.
not as a revenue raising measure.
Yes.
Okay. So you went back and forth with Justice Gorsuch about the implications of the president's authority over foreign affairs and whether the major questions doctrine applies. You say that in IEPA, the president's war powers are not implicated, and that was part of the reason why you say that we should think of this differently than some of the historical examples where the commander-in-chief war powers were implicated. But the same language appears in the Trading with the Enemies Act, in which war powers would be implicated. So do you think the language should be, and of course that is what President Nixon relied on, so do you think that the language would be interpreted differently in that context, even though the commander-in-chief power and the war power would be implicated?
100%, I think it would be interpreted differently. Justice Jackson.
Same regulate commerce language.
Yes, because once you're carrying over wartime precedents to peacetime.
Okay, I don't understand that then, because everybody agrees the language in IEPA came from the Trading with the Enemy Act. So you're saying it has one meaning in the Trading with the Enemy Act and a different meaning in IEPA, that same regulate commerce?
No, I think that the conquered territory language and all of that may go to the president's Article 2 powers as inherent powers in conquered territory, but I don't think it gets the government where they need to go. The CAC brief and the brief by Professor Paul Stephen goes through and explains why in 1933, when Congress decided to bring these concepts into peacetime, it severed the wartime roots, and there's an extensive legislative history.
Okay, I understand that, but I thought that was about, maybe I'm just not tracking. I mean, I think there's been some discussion of whether the president would have inherent Article 2 authority in wartime to impose tariffs to this end. Is that what you're talking about? Are you actually talking about a statute that said regulate importation in wartime?
Right.
And you think it could have the tariff power conferred through that language in a war-making statute, but not in IEPA?
No, I don't think it confers it in either place. I think the president the president's power in conquered territories, not in the Trading with Enemies Act or anything like that.
Okay, so it's an
rather
inherent constitutional
exactly.
power coming from the law of war. Okay. And then if you win, tell me how the reimbursement process would work. Would it be a complete mess? I mean, you're saying before the government promised reimbursement, and now you're saying, well, that's rich, but how would this work? It seems to me like it could be a mess.
So the first thing I'd say is that just underscores just how major a question this is. The very fact that you were dealing with this with quotas, there's no refund process to the tunes of billions of dollars or embargoes, but there is here. But for our case, the way it would work is, in this case, the government stipulated for the 5 plaintiffs that they would get the refunds. So for us, that's how it would work. Your question, I take it, is about everyone else. We don't have a class action or anything like that. With respect to everyone else, there's a whole specialized body of trade law, and it's in 19 U.S.C. 1514 outlines all these administrative procedures. It's a very complicated thing. There's got to be an administrative protest. There was a harbor management case earlier that this court was involved with in the United States Shoe, in which the refund process took a long time. There were any number of claims and equitable relief.
So a mess.
So it's difficult,
Okay.
absolutely. We don't deny that it's difficult, but I think what this court has said in the McKesson case in 1990 is that serious economic dislocation isn't a reason to do something. Northern Pipeline, you guys stayed your decision for a while in order to let the congressional process unfold. There may be a congressional process here as well. You may be able to also be that this court could limit its decision to prospective relief under the John Q. Hammond's case. So there's lots of possibilities.
Justice Jackson?
So I think I read Algonquin differently than Justice Kavanaugh. When I look at its analysis, it absolutely does a textual review, but then it says, quote, turning from Section 232's language to its legislative history, again, there is much to suggest that the president's authority extends to the imposition of monetary exactions. And I appreciate that perhaps that factor is no longer in vogue, but did you look into the legislative history here to determine whether there is anything that supports the conclusion that Congress actually intended for this IEPA statute to allow or authorize the president to impose these tariffs?
I did, and if I blinked, I would miss it because it was virtually nothing. And in fact, both page 2 of both the House and Senate report outline all of the powers that are given under IEPA, and none of them have tariff. There's one brief mention of tariff in the legislative history, but nothing else. And by the way, IEPA passed by voice vote. It was, there was not controversial. We don't deny IEPA as a big, major statute, but the question is, did it authorize tariffs? One of the most contested things since our founding.
And you say there's nothing in the legislative history to suggest it. Now, to the extent that Congress did authorize the president to do something, that those verbs are there, that the Congress was giving the president some authority, do you see a theme connecting those verbs? What was Congress trying to do? And let me just say that I see in the Senate report, which I mentioned earlier, that Congress says that it was trying to give the president the authority to, quote, control or freeze property transactions where a foreign interest is involved. And that seems to dovetail with the verbs that are being used in the statute. But what's your view of what Congress was trying to do with this legislation?
That's exactly right. They're responding to all sorts of foreign policy emergencies and foreign threats, and they're giving the president economic sanctions power.
So what does the word regulate importation do under that framework? If we understand that Congress was trying to give this kind of embargo authority in the time of an emergency, when it says regulate importation, what was it envisioning?
It was envisioning all the things that the president since 1977, going back to Justice Kavanaugh's question, have used it for. So they've used it for quotas, like limitations on the number of goods. They've used it for screening and reporting requirements, like Executive Order 12284 about reporting property of the Shah. And they've used it for standards, like domestic safety standards, environmental standards, labor requirements. They've used it for embargoes. So all of those are things that I think Congress had in mind in IEPA, And I think the proof of this, that it's not this massive statute that allows the government to do anything, is Dames and Moore itself, because this court rejected the idea that regulate includes the claims extinguishment that was at issue in that case. It's a much more limited statute. And Justice Jackson, there was a predecessor, Justice Jackson, who said, that, quote, for all its defects, delays, and inconveniences, men have discovered no technique for long preserving free government except that the executive be under the law and that the law be made by parliamentary deliberations. Such institutions may be destined to pass away, but it is the duty of this court to be last, not first, to give it up. And I take it my friend's argument on the other side is in deep tension with Youngstown and that canonical principle.
Thank you.
Thank you, counsel. Mr. Gutman?
Mr. Chief Justice, and may it please the court. I'd like to begin by picking up with the exchanges with Justice Barrett and Justice Gorsuch about licenses and license fees, because I think we ended on the right note, but I just wanted to make sure that at least my client's position is clear on this. Licenses are different from license fees. And I am not aware of any history in the 5 decades that IEPA has been in force of any fees charged for the licenses under this statute. This is a statute that licenses can be used. For example, the president might ban certain transactions with a foreign country, but then grant licenses to do them for humanitarian reasons. But as far as I'm aware, there's never been a fee charged for that. And I do welcome the court's questions. But I think I just want to make absolutely clear.
I think the question is, what does or otherwise do?
Well, or otherwise could be things like instructions or licenses, but again, it's fundamentally having something that is a revenue-raising measure or even that is just an exaction of some sort is fundamentally, categorically different from what we understand instructions and licenses to be involved, just like we think regulate doesn't carry the financial connotation given the other verbs there. If I could turn to some of the 19th century history that we were discussing as well, because I think there may be a little bit more to add there. The 19th century cases about the president's inherent Article II authority to, with respect to, in a wartime, with respect to importation is not the power to impose tariffs on imports coming into the United States. That is not what any of those cases were about. They were about the president's power, in a wartime as an occupying military force to impose tariffs in occupied territory, that in Mexico, in the Philippines, in California. The Civil War case might be the closest case, but even there, what we were talking about were essentially, there were licensing fees, but they were export fees. They were fees that were being imposed on the exportation of cotton from the occupied South into the North. And so I don't think any of that provides authority for this general notion that there is a background principle that the president, even in wartime, has an Article II authority to impose tariffs, certainly without the consent of Congress.
So you agree, I assume, given all the verbs in this list, that the president could do something like just shut down all trade between us and, say, China, right?
Yes, I mean, there are other limitations.
Okay, so doesn't it seem, and I think this is one of the points that Algonquin makes, and I think it's a point that Justice Kavanaugh was making, doesn't it seem then, I mean, I don't want to use the phrase lesser power, lesser included measure, but doesn't it seem like it would make sense then that Congress would want the president to use something that was less, weaker medicine than completely shutting down trade as leverage to try to get a foreign nation to do something?
And the president can in the form of, for example, quotas. But what makes an embargo or quotas fundamentally different from tariffs, as my friend has already explained, is the revenue-raising aspect of that. That makes it a far more significant power. It creates additional danger of overuse. And I think the other point, as Justice Jackson was pointing out, is that it cedes control over whether the transaction occurs from the government to the individuals engaging in this transaction. And that is not what IEPA is intended.
What makes something revenue raising? I mean, fees raise money, and
Yes.
unless they're going to be kind of one-to-one, this is exactly what it costs. I mean, it might raise some surplus. It might raise some extra. So is it the purpose? If the purpose of the fee or the tariff is to raise money,
I
is
don't
it
think
the purpose that makes it revenue raising, or is it just the fact of surplus created that goes to the treasury? Like, how do we decide this?
Yes, I think it's the effect. And to be clear, I think there would be a serious difficulty with interpreting any of these words, even to allow revenue neutral exactions here, because none of them. And again, as far as I'm aware, IEPA has never been used in that way. But I don't
Not
think
even a processing fee?
I am not aware of any use of that sort of under IEPA. But even if that is permissible, I think that's permissible precisely because it doesn't have the effect of raising revenue.
Mr. Katyal referred to common sense several times, and I want to pick up on Justice Barrett's question because your interpretation of the statute, as she pointed out, would allow the president to shut down all trade with every other country in the world, or to impose some significant quota on imports from every other country in the world, but would not allow a 1% tariff. And that leaves, in the government's words in its brief, an odd donut hole in the statute. Why would a rational Congress say, yeah, we're going to give the president the power to shut down trade? I mean, think about the effects. But you're admitting that power's in there.
Yeah.
But can't do a 1% tariff. That doesn't seem, but I want to get your answer, to have a lot of common sense behind it.
I think it absolutely does because it's a fundamentally different power. It's not a donut hole. It's a different kind of pastry.
And on that power, that's a good one. On that power, though, and you've said this many times, and Mr. Katyal too, and look, I get this, obviously, but the court has repeatedly said a tariff on foreign imports is an exercise of the commerce power, not of the taxation power. And I'm repeating but John Marshall said that, and Joseph Story, and Chief Justice Hughes in the 1933 case, and we've said that quite a bit of time, which seems to at least undermine a bit your point that it's an entirely different power, because if it is foreign commerce power, it's the same power that Justice Barrett was talking about of just embargoing trade with the entire world, which you admit is in this statute.
Well, there are a couple of points in there, and I'll try to get to all of them, but I mean, I think all of us agree that context is what matters here, and that you certainly could use the word regulate to talk about a tariffing power, like you could use it to talk about a taxing power. We impose taxes for regulatory purposes as well. But the federal government hasn't identified a single other federal statute that uses the term regulate to authorize tariffs or taxes. That is just a different kind of power.
And I thought your point in response to Justice Kavanaugh, it's a different kind of power because the power that's being authorized by this statute is the power to control or freeze trade.
That's
what Congress was getting at. And so if that's true, then we have to read regulate in that context.
That's exactly right. And I think the reason, getting back to common sense as to why a legislature might authorize that, is that you might not fear abuse of that power in the same way that you would be concerned about abuse of a power to impose unlimited taxes with sort of no controlling principles.
Well, why is that? Because, I mean, there is a sort of commonsensical intuition that one is, in Justice Kavanaugh's example, that one is greater and one is lesser. So why is that not right? Because,
to be blunt about it, there's nothing, one of them there's something in it for the government and one of them there isn't. Actions that bring in revenue from the pockets of taxpayers to the Treasury pose a different set of concerns. Our framers were very concerned about that.
A different set of concerns, how, why?
Because they bring in revenue. And because that creates
Well, that seems a little tautological. Like, why is it that the revenue raisers are in a different category?
Because look, if there is some sort of international emergency and the appropriate way to deal with it is to make sure that no more than 1,000 of this product comes into this country at a particular time, this statute gives the president the power to ensure that exactly no more than 1,000 come in at this time. Setting a tariff doesn't ensure that only 1,000 will come into this country. It cedes control over whether the transaction occurs, and what it does is it then adds revenue to the Treasury, and that is again something that our framers thought was extremely important and a core Article 1.
But Algonquin, I mean, this kind of goes back to Justice Kavanaugh's point. Algonquin rejects the idea that it was impermissible to use the fees, and we can call them, license fees that functioned as tariffs or duties in that case, whatever. But Algonquin said that Congress could use the exaction of money to control quantity. And I hear what you're saying is like, well, you can control quantity by numbers by imposing hard limits, but not by money. But that's not what Algonquin said. So I guess.
Oh no.
Why?
Well, I don't mean to suggest that you can't use exactions to control quantity. What I think Algonquin just shows the importance of context. It might be perfectly natural to read a phrase like adjust imports in the context of a statute that talks about tariffs, in the context of the Trade Expansion Act that has all sorts of provisions about tariffs and about the president adjusting tariff rates. It might be perfectly natural in that context to read a phrase like adjust the imports to be referring to changing tariff rates. It's just as unnatural to read a phrase like regulate importation to discuss that when the statute has nothing to do with tariffs and doesn't otherwise mention tariffs at all.
And do you think imposing tariffs is do you think that just blocking all trade is a bigger deal than imposing a 1% tariff across the board?
I think it would be a huge deal. It is just a different kind of deal.
Algonquin was not a constitutional case, right?
Correct.
It was a statutory interpretation case.
Correct.
And so the question there was simply, was Congress actually trying to give, or did Congress in that statute give the president the authority to impose these kinds of exactions? And the court looked at the text, and it looked at the legislative history in which there was a number of clues that Congress had actually intended to do that.
Yes,
right?
yes, and it looked not just at the text of those specific words, but also the context of what else was in the statute and the fact that some of the factors that the president was supposed to be considering.
Keep going.
And it would make perfect sense, I think, in a time of emergency for the many of the reasons that General Sauer pointed out, that Congress would want the president to have the kind of authority that is imposed when you are embargoing things, when you are stopping the trade, when you are saying, for emergency reasons, we're not letting any of this product come in. I mean, sure, that's a big deal, but the nature of it makes sense in terms of an emergency. I think what you're saying is that the idea that the government would use its authority to be raising revenues in this situation is a different kind of power.
Exactly. This is a statute about giving the president control over assets, over transactions, over access to banking.
And tariffs don't do that. You said something about
exactly
tariffs
right.
Tariffs in fact cede control
Exactly
over
right.
those sorts of things. So they sort of undermine the goals and the purposes of this kind of statute. Is that right?
Yes, that's exactly right.
Can I
From
ask-
what you said,
Go ahead.
From what you said, it seems, and you said this, that the reason for drawing a distinction between tariffs and an embargo is the suspicion that tariffs will be used to raise money and therefore to circumvent Congress's power to control taxes. So it's a question of the risk that's involved. Am I right?
Yes.
That's what it boils down to.
Yes, well, and it's a question of understanding what Congress would have thought what powers Congress would have thought it was conferring. Would Congress have understood the phrase regulated?
Well, I mean, the question is, why would Congress say you can impose a quota, you can impose a ban, but you can't impose a tariff? And your answer, I gather, is because when a tariff is imposed, we're suspect about what's going on. We're suspicious about what's going on. We think that what the government is trying, what the executive is trying to do, is to raise revenue, and that's our business, right? That's what it has to be.
Yes, and we know that every other time that Congress has authorized the
Well, that's
president.
it, you're getting into a different argument. Then, would you say the same thing if the measure is really about an emergency? An
Yes.
undisputed emergency and a really dire emergency?
Yes.
There, would you have the same suspicion?
Yeah, yes, absolutely. And again, I'll refer back to Justice Jackson's concurrence in Youngstown that emergency powers tend to breed emergencies. Look, Biden versus Nebraska, I think, says very clearly.
I really don't think you're answering the question. The question is, would you have the same suspicion when it is perfectly apparent from context that what the president is trying to do is to achieve a goal other than the raising of money?
I think what I'm trying to say is that you have to read the statute the way that Congress would have understood it when it was enacted, not how it is used in any particular case. It may be used for very good reasons in a particular case, but the question is, would Congress have understood itself to be ceding this power with no limits, unlike every other tariffing statute with no
All right,
limits?
I know that point. Let me ask you an unrelated question. Mr. Katyal listed some of the things that presidents have done under IEPA, such as screening imports. Do any of the other verbs in IEPA talk about could screening of imports be done under any of the other verbs in IEPA?
I think maybe, but it would have been
Which one?
prevent. And so I think the question would be,
Screening is preventing?
Well, I think it depends what you're screening for. But if you were,
Okay, how about imposing domestic requirements that are needed to safeguard domestic safety? Any other provision besides regulate? Any other verb besides regulate that would?
Well, again, I think if we're talking about potentially blocking some property from coming into this country because of safety concern, it might be that prevent would have gotten you there. What I think regulate does is it clarifies and amplifies that you don't just, it can be nuanced in that way. It can say, we will let this come in if it has certain safety requirements, if certain features have been disabled, something like that. And I think regulate harmonizes with prevent, investigate during the pendency, block during the pendency of an investigation, those sorts of.
On the context point, the context of this statute, what Congress would have understood, it's an emergency statute. And presumably Congress wants to give the president tools to respond to the emergency in an appropriate way. And it seems odd to imagine a meeting in the Oval Office where the president's told, well, we have a problem with, I won't name a country, but country X, and you can stop all trade with that country. I mean, I'm not sure that's a, wise policy to give that much, but it's there, right? You agree it's in this statute. And the president says, well, that's too extreme. I want to calibrate my response to deal with this, and maybe a tariff of some kind. Like, well, you can't do that. So you're forcing the president to respond to an emergency. And, Justice Alito's raised the point about, a real emergency. And you're taking away the president's suite of tools when the one is much more extreme that is authorized. That just seems a bit unusual. Think about India right now, the tariff on India, right? That's designed to help settle the Russia-Ukraine war, as I understand it. Don't pretend to be an expert. But if that's gone, that's a tool that's designed, talk about foreign facing, the most serious crisis in the world. And that's out the window. So I just think it's just contextually emergency. It's just a bit unusual to read it that way. But I take your response. Taxation's different, and you got to stick with that line.
No, and I don't think it's just that, because I do think it's that, but it's also that there are a range of tools that are more calibrated that the president can do. It doesn't have to be a complete embargo. It could be limits on particular kinds of products. It could be quantity.
I get it, but in the history of trade efforts to respond and push back, you're taking one away.
Well, and the president, and there are many other statutes that might apply depending on the
get
exact
that.
circumstances,
Fair,
201, 301, 230.
Counsel, I
That's a good
think what
point.
we're forgetting here is a very fundamental point, which is the Constitution is structured so that if I'm going to be asked to pay for something as a citizen, that it's through a bill that is generated through Congress and the president has the power to veto it or not. But I'm not going to be taxed unless both houses, the executive and the legislature, have made that choice, correct?
That's exactly right. So
And so there is something, it's not just the taxing power, qua taxing power. The question is, do we permit the president to use the taxing power to affect his personal choices of what is good policy for me to pay for?
that's exactly right. The question is
It
who
hasn't-
decides.
Who decides and under what circumstances? Now, with respect to this, I mean, I'm not even going to the pretext argument, okay? But the president threatened to impose a 10% tax on Canada for an ad it ran on tariffs during the World Series. He imposed a 40% tax on Brazil because its Supreme Court permitted the prosecution of one of its former presidents for criminal activity. The point is, those may be good policies, but does a statute that gives without limit the power to a president to impose this kind of tax, does it require more than the word regulate?
Exactly.
That's your point.
Yes.
Thank you, counsel. Did Mr. Cocktail say anything this morning with which you disagree?
No, I think we cleared up any maybe potential disagreement about licensing fees, but I think we all agree on that.
Okay. Justice Thomas? Anything further? Justice King? Justice Gorsuch?
So I just want to follow up on Justice Sotomayor's question at the end of a long morning, afternoon. It does seem to me, tell me if I'm wrong, that a really key part of the context here, if not the dispositive one for you, is the constitutional assignment of the taxing power to Congress. The power to reach into the pockets of the American people is just different, and it's been different since the founding and the Navigation Acts that were part of the spark of the American Revolution, where Parliament asserted the power to tax to regulate commerce. Some of those were revenue raising, some of them didn't raise a lot of revenue. We had a lot of pirates in America at the time. And Americans thought even Parliament couldn't do that that had to be done locally through our elected representatives. Isn't that really the major questions, non-delegation, whatever you want to describe it, isn't that what's really animating your argument today?
I think it's a huge piece of what's animating our argument. Thank you.
Ms. Kavanaugh? Justice Jackson?
Can I just invite you briefly to address your kind of second tier arguments? Assuming that the president can impose these sorts of tariffs, why do you think, for example, that the trafficking tariff here does not deal with the drug trafficking emergency for the purpose of this analysis?
So it doesn't deal with it because it's not a sanction imposed against traffickers. It is if you think of it as a sanction, it is a sanction imposed against people importing lawful goods in the home.
Doesn't that that happens all the time, right? I mean, all the other authorities indirectly provide leverage on countries in this way.
I don't think so. I think that they are, the history of IEPA and even of TWIA is imposing sanctions directly on the wrongdoers. These are statutes about providing sanction authority against international actors whose behavior we want to change. And that's not what tariffs are.
All right, thank you.
Thank you, counsel. Rebuttal, General Sauer?
Thank you, Mr. Chief Justice. Just 3 points. One, an interpretive point. The statutory language here is regulate importation, and again, by means of instruments, licenses, or otherwise. Their argument is that that phrase carries with it a whole host of unenumerated forms of regulation, including quotas, licenses apparently that come with fees as long as they're not as long as they're sort of profit neutral fees, environmental restrictions, qualitative restrictions, reports, and so forth. It's just that the one form of regulation that they would not include is tariff regulation, which of course is the quintessential, most historically tested method of regulating imports. And so that additional phrase about, by means of instruments, licenses, or otherwise, really sort of reinforces the plain meaning, the ordinary, natural meaning of regulated importation here. So when it comes to just the plain text of the statute, their argument is a donut type argument, and it's not an argument that does justice to the statute's plain text. On the non-delegation point, Justice Gorsuch, you alluded to the founding or delegations of the Indian commerce power, and I just remind the court that in 1790, in July of 1790, Congress passed a statute that essentially delegated to President Washington essentially the entire scope of the Indian commerce power. He said you can do commerce with Indians if you have a license that you have to pay a fee for, and that will be subject to such rules and regulations as the president makes with no further guidance. So when it comes to this foreign-facing, there it's obviously analogous because it's the Indian tribes, not the foreign sovereigns, but this foreign-facing situation, we have a very sort of deep and profound historical pedigree through broad delegations of the regulation of commerce, right? The foreign commerce power, in that case, the Indian commerce power. And that ties, I think, to what I take to be the main theme of the arguments on the other side. And I think that Mr. Catchall started by saying tariffs or taxes. And I want to complete the answer I think I was giving to the Chief Justice when I got interrupted is if you look at these tariffs, these policies, it is clear that these policies are most effective if nobody ever pays the tariff. If it never raises a dime of revenue, these are the most effective use of this particular policy. And I said there's two buckets there. One is, first of all, when it comes to the trade deficit emergency, if no one ever pays the tariff, but instead they direct their consumption domestically and spur the creation of the rebuilding of our hollowed out manufacturing base, that directly addresses the crisis. It's more effective if no one ever pays the tariff. That's the point of it, really. That's a fundamental point of it. And that's one piece of these. And then as to both of them, as to both of the declared emergencies, the tariffs are an incentive, a pressure point, leverage, bargaining chip, as the court said in Dames and Moore, to get countries to change their behavior to address the foreign arising emergencies. So if you look, for example, to take a historical example, last week's trade deal with China, it unlocked access to rare earth minerals, which of course have a critical national security aspect to them, and it got China for the very first time to change its policy with respect to fentanyl precursors, which is a crucial piece of that. Those tariffs, if no one ever collects them, but the threat of imposing those tariffs gets China and our other trading partners across the world to change their behaviors in a way that addresses this, then that's the most effective use of the policy. So they're clearly regulatory tariffs, not taxes. They are not, they're not an exercise of the power to tax. They are the exercise of the power to regulate foreign commerce. And that's why the statute says regulate. It doesn't say tax, it says regulate. And for that reason, we are squarely within the tradition that I was talking about before of very broad, historically very broad delegations of the power to regulate foreign commerce to the president because he has inherent Article 2 authority in the area of foreign affairs, although not that. It has to be delegated to him, otherwise the delegation would be superfluous. And for all those reasons, we ask the court to reverse both the decisions below.
Thank you, counsel. The case is submitted.